So far in this course, we have covered three primary topics. We started by looking at the scope and coverage of UCC Article 2, asking which transactions does Article 2 apply to. Then we moved on to questions of mutual assent and contract formation, looking at the similarities and differences between how agreements may be reached under the common law of contracts versus UCC Article 2. And in last week's module, we focused on questions of enforceability by examining the two defenses to enforceability codified in Article 2, the statute of frauds and the doctrine of unconscionability. In this week's module, we will move on to a new topic, the terms of a contract. We will assume that we have an enforceable agreement, but now we need to know what are the terms of that contract? What are the terms that govern the parties' rights and obligations? To answer this question, we will start looking at the many different ways that the UCC Article 2 provides for determining the terms of a contract. Specifically, we'll start by examining the UCC's concepts of course of performance, course of dealings, and usage of trade. Then we'll move on to the implied duty of good faith. And finally, we'll look at how existing contracts may be modified under UCC Article 2. But let's start at the beginning. We already know that when two parties objectively manifest assent to an agreement through their words, the parties may form a contract binding themselves to the express terms they have agreed to. Our focus in this week's module will be on two related questions. First, what additional terms might supplement the parties' agreement? This again turns on the distinction between a contract and an agreement. Remember, an agreement is the parties' bargain in fact, what the parties actually agreed to, whereas a contract is what is legally enforceable, the total legal obligations arising from the parties' agreement. An agreement is the basis for a contract, but the contract is what is legally enforceable. In last week's module, we discussed how the parties' contract may be less than what the parties expressly agreed to. For example, if some of the terms that the parties agreed to are unconscionable. One of the issues that we will look at in this week's module is how the parties' contract may be more than what the parties expressly agreed to. Specifically, we'll look at the many ways that contract law, and in particular UCC Article 2, supplement or add to what the parties expressly agreed to. A second related question that we will look at in this week's module is, what do the express terms of the parties' agreement mean? How should we interpret the express terms the parties agreed to? What if those express terms are themselves ambiguous? Stated differently, what if the words the parties use to describe their agreement are reasonably susceptible to more than one meaning? The first place to look to answer these questions is something that we will take up in the next video, course of performance, course of dealings, and usage of trade.